Hello, my name is Alex. I'm currently a student at Seminole State College of Florida, and I'm currently taking a course on the Introduction to Criminal Justice, and as such, today I will be talking to you about Gideon versus Wainwright, a Supreme Court case which was heard in 1963, and that case is a monumental Supreme Court decision which affords an attorney to be present regardless of your wealth. If you cannot afford an attorney, one will be appointed to you. So how this case came about was a burglary occurred on June 3, 1961 at the Bay Harbor Pool Room in Panama City, Florida. This occurred somewhere between the hours of midnight and 8 a.m. Clarence Earl Gideon, an indigent man in the area, was seen around the vicinity of the pool hall with a lot of money as well as a bottle of wine, and he was charged with breaking and entering and with intent to commit petty larceny. An eyewitness saw him leaving. Gideon himself was too poor to afford counsel, and he wanted an attorney to be appointed for him, and the court said under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. But Gideon said, the United States Supreme Court says that I am entitled to be represented by counsel. So Gideon went on to defend himself. He was sentenced to 5 years in state prison, where he read and educated himself on the laws of the land, and he spent all of his time in prison very wisely. He read up in the library, and then he appealed, and the case was escalated to the Supreme Court. And it was a rather quick turnaround for our legal system, as the burglary occurred in 1961, and the decision was reached March 18, 1963. The Wainwright mentioned in Gideon v. Wainwright was the Secretary of the Florida Department of Corrections. Gideon initially filed his suit against Cochran, who was the former Secretary of the Florida Department of Corrections. But he retired and Wainwright took over. So this may give you a leaning as to where the Supreme Court was headed. So the Supreme Court appointed Gideon an attorney, which was what this whole fight was about. They appointed him an attorney for his fight against the Supreme Court, Abe Fortas. And there were two prior Supreme Court cases, one of which was the Powell versus Alabama of 1932, when 9 black men were charged with a murder, and that case stated the Sixth Amendment right to counsel as well as the 14th Amendment right to a fair trial, and they appointed the 9 black men an attorney. But in 1942, 10 years later, Betts versus Brady, where if a man is tried for robbery, due process of law does not demand that Maryland furnish counsel to an indigent defendant, unless they are illiterate or very stupid. As the 1932 case did not apply to non-capital crimes necessarily. But then Betts versus Brady was overturned by the decision of Gideon versus Wainwright, and now after the verdict of Gideon versus Wainwright, everybody is entitled to an attorney. If you cannot afford an attorney, one will be provided to you. That was 2 subsequent cases dictate that. Messiah versus United States in 1964, which extended that rule to apply to police interrogation, and Miranda versus Arizona, which everyone is familiar with, the Miranda rights. And that was a case in 1966, and now every person charged with a crime is aware of their rights. This verdict ultimately freed 2,000 individuals in Florida alone. It granted Gideon a new trial, and he was acquitted after 1 hour of deliberation after some inconsistencies in the witness statements. and he was freed 5 months after the Supreme Court decision. Gideon died of cancer in Fort Lauderdale 9 years after the verdict on January 18, 1972, at the age of 61. A quote from a letter that Gideon wrote to Abe Fortas appears on his headstone. Each era finds an improvement in law for the benefit of mankind, and I believe that Gideon versus Wainwright did just that.